MCA notification 22nd January 2021 from Companies Corporate Social Responsibility Policy Rules 2014 to Companies Corporate Social Responsibility Policy Amendment Rules 2021. Hello everyone, welcome to my channel. I am CS Jaspreet. If you haven't subscribed to my channel yet, please subscribe to it as I make educational and informative videos for CA, CS and CMA students as well as members. Today's video is a very important notification by MCA dated 22nd January 2021 regarding Companies Corporate Social Responsibility Policy Amendment Rules 2021. Do watch the video till the end, but before that, please subscribe to my channel and you won't regret it. So starting with the short title and commencement, the rules may be called as the Company's Corporate Social Responsibility Policy Amendment Rules 2021, and they will come into force on the date of publication in the official gazette unless explicitly provided elsewhere. Now in this case, the publication date is 22nd January 2021 itself, so they are applicable as per 22nd January 2021. Now, Rule 2 in Companies Corporate Social Responsibility Policy Rules 2014 was dedicated to definitions. In this rules also, Rule 2 is definition, but that whole rule is substituted with the new Rule 2 definitions in which these definitions are stated. Starting with the first act, wherever act is written, it means Companies Act 2013. Administrative overheads are the general management and administration of CSR functions, but they exclude whatever the expenses that are being spent while designing, implementing, monitoring and evaluating any kind of CSR project or program. They do not constitute administrative overheads. The administrative overheads, they are just the general management and administration of CSR functions. Annexure means the annexure that is appended to the rules. Now, what is CSR? CSR is defined. These are the activities that are undertaken by a company of its statutory obligations laid down in section 135. So basically CSR was introduced just to do good to the society, give it back to the society which is investing in your plans, in your companies. You should also do something for them. So that is why section 135 came up, that you have to give back something to the society in simple words. Now there are certain activities, like activities undertaken in pursuance of normal course of business of the company. Like in these activities, of the new vaccine, drugs and medical devices in the normal course, which include research and development related to COVID-19 for financial years 2020, 21, 2021, 22, 2022, 23, subject to the conditions that are subjected to regarding the vaccine development related to COVID-19 are that such R&D activities, whatever the R&D is taken up, if you want that activity to be constituted under CSR activities, that has to be in collaboration with the institutes or organizations which are mentioned in item number 9 of Schedule 7 to the Act. So Schedule 7 to the Act has already given the institutes or organizations. Alongside that, if you're collaborating with them and making any kind of vaccine that is related to drugs or anything related to COVID-19, then only you are eligible to call it as CSR activities. And whatever the details of the activities, you have to disclose it separately in the annual report. You have to tell everything about the activity in the annual report that is included in the board's report. Now, second is any activity if it is taken place outside India, like it's not in India, it's outside India, excluding, but it does not constitute, it excludes the training of Indian sports personnel representing any state or union territory at national level or India at national level. So these things, the trainings of Indian sports personnel, they don't constitute in the activity that is undertaken outside India, but except that if there is any other activity, that will come under CSR activities. Then contribution of any amount to any political party, whether it's directly or it's indirectly, under 182. section 182 of the Act. Then activities benefiting employees of the company. Now there is a clause K of section 2 of the Code on Wages 2019. In under this clause, if any company is, benefiting the employees of the company, those activities are also termed as CSR activities. Or if the companies, they are supported on sponsorship basis for deriving the marketing benefits for its products or services, those activities are also CSR activities. And activities carried out for fulfillment of any other statutory obligations under any law enforced in India. So these all will be constituting the CSR activities. What is a CSR committee? It's just the committee of the board that is referred in section 135 of the Act. CSR policy. It means a statement containing the approach and direction that is given by the board of the company, taking into account the recommendations of its CSR committee, and includes guiding principles for selection, implementation, and monitoring of the activities, as well as formulation of the annual action plan. So this is what you call CSR policy. It will be given by the board, what recommendations you have to take of the committee regarding the selection, implementation, and monitoring of the activities, and formulation of the annual action plan as well. Moving forward to the definition of international organization. Now, it's an organization which is defined under Section 3 of the UN Privileges and Immunities Act 1947. Then what is a net profit? Now, net profit of a company, it is the profit as per the financial statement that is prepared in accordance with the applicable provisions of the Act, but it does not include if the entity has any profit from any overseas branch or branches of the company, whether operated as a separate company or otherwise, but whatever the profit it's coming from those overseas branches, that is not included in this net profit. And if you receive any kind of dividend from other companies in India which are covered under section 135, that is also not included in this. And provided that in case it's a foreign company covered under these rules, then the net profit would be net profit and loss that will be prepared in terms of clause A of subsection 1 of section 381, read with section 198 of the Act. Now, what is an ongoing project? It's like a multi-year project that is undertaken by a company for its CSR obligation, having timelines not exceeding 3 years. That kind of a project is called ongoing project, that there's a time limit also that you have to complete it within this time as it was commenced, and shall include such project that was initially not approved as a multi-year project but with the duration has extended beyond 1 year by the board based on reasonable justification. It will also, suppose when the project got started, at that point of time it was not big enough to be called as a multi-year project, but then afterwards, eventually, according to its growth and everything, the board, based on reasonable justification, it has extended the time limit, so that will also be included in the ongoing project. Public authority means that is defined under clause H of section 2 of RTI Act 2005. Section means a section of the Act. Now, in case any word or any expression is being used in the rules, but they are not defined, okay, so but it is being defined in the Act itself, so the meanings will remain same because it is already being defined in the Act. Rules are a part of Act only, so that is why whatever is not defined here in the rules but is used, the words are used here if they are defined in the Act, so the meanings will go as per the Act only. Moving to the amendment in rule number 3. So in rule number 3, there is a sub rule 2. In clause B, you can see I have put the screenshot underneath. So in clause B, it was earlier written subsection 2 to 5 of the said section. It is being substituted to subsection 2 to 6. Now it should be read as comply with the provisions contained in subsection 2 to 6 of the said section. Next amendment is regarding substitution of rule 4. Now before in companies, CSR Policy Rules 2014, Rule 4 was named as CSR Activities. But now, in this amendment, in Company CSR Policy Amendment Rules 2021, Rule 4 is named as CSR Implementation. Now, I'll be giving you an overview that what all is in the CSR implementation under Rule 4. Now, what is in Rule 4 that states CSR implementation? So it says that the board, they have to make sure that CSR activities are undertaken by the company itself. It is the duty of the board of directors to make sure that the activities regarding to corporate social responsibility are being taken place by the company or through either they'll do it itself or through a company under section 8 or a registered public trust or a registered society under section 12A and 80G of IT Act 1961 established by the company either singly or along with any other company. So these are the companies, either they are established like singly like by its own or along with other companies. Then company under section 8 or registered trust or registered society that is established by the central government or state government. Then any entity that is established under an act of parliament or state legislature, or a company that is established under section 8 or a registered public trust or a registered society or registered under section 12A and 80G of IT Act, and they have a track record of doing the similar things, carrying out the similar activities for at least 3 years. So this is the first sub rule that states that the board has to ensure, the board has to confirm and take care that CSR activities are being taken place by the company itself or through these companies that are being stated in sub-rule 1. Now comes a very important amendment that is under sub-rule 2, that is regarding the CSR 1. Now it is an e-form that is being inserted. I'll be explaining about this e-form CSR1. It is next at the end of the video. So it is at the end. So we watch the video till the end, and I'll be telling you that every company, every entity which is covered under sub-rule 1 and they want to undertake any CSR activity, you have to register yourself, your entity with the central government by filing form CSR1 electronically with the registrar with effect from first day of April 2021. So you will have to file the form CSR1. I'll put this timestamp here. You can directly go and see a format of e-form CSR1 that I've told that I'll be explaining at the end. So that filing would start from 1st April 2021 regarding every entity that is covered under sub-rule 1 and they intend to undertake the CSR activity. Registration is must with the central government by filing the e-form CSR1. Now there is a provision. It says that provided the provisions of this sub-rule shall not affect the CSR projects or programs approved prior to the first day of April 2021. So if there is any project or program that is being approved before this day, prior means before 1st April 2021, that will not come under this sub-rule for the filing of this form. So it will basically take place from with effect from 1st April 2021. Then form CSR1, it shall be signed and submitted electronically by the entity, and it should be verified digitally by CA in practice or CS in practice or CMA in practice. Any one of the three could digitally sign it. Basically, it's a digital verification by any of the one professional who is in practice, and CSR1, it should be then submitted and electronically by the entity itself. Now on submission of form CSR1 on the portal, a unique CSR registration number shall be generated by the system automatically. The moment you submit this e-form CSR1, a unique CSR number will be generated, that is automatically. So moving forward with rule 4 that says CSR implementation, the sub rule 3 states that the company, they can engage also with the international organizations, for designing, for monitoring, and for evaluation of the CSR projects and programs as per its CSR policy, as well as if they want to, capacity building of their own personnel for CSR, they can even go and engage with the international organizations for CSR implementation. Then a company may also collaborate with other companies for undertaking projects or programs in such a manner that CSR committees of respective companies are in a position to report separately on such reports or programs in accordance with these rules. Now, you may go and collaborate with other companies, but your CSR committees should be able to report accordingly what your company is doing for the CSR activities. Now, the board of a company, they shall satisfy itself that the funds so dispersed have been utilized for the purposes in the manner as approved by it. This is the responsibility of the board of directors, that whatever funds that are being kept for CSR, they are properly, dispersed, they are properly being utilized for whatever purposes they are assigned to. Right? That is the management, that is the duty of the management, and the CFO, that is the chief financial officer, or the person responsible, shall certify to the effect. He will have to certify that yes, whatever the funds were there dispersed for this purpose are being utilized for this purpose, and they are not misused or they are not misappropriated in any kind. In case of any ongoing project, the board of a company, they shall monitor the implementation of the project with reference to the approved timelines and year-wise allocation, and shall be competent to make modifications for smooth implementation. So it's very important. Again, board has to take care that it is being implemented, timelines are being followed, year-wise allocations are there. It is all on the shoulders of the board of directors of a company. Moving forward to the next amendment, that is in substitution of sub-rule 2 of Rule 5. Now, before the sub-rule 2 said that the CSR committees shall institute transparent monitoring mechanism for implementation of the CSR projects or programs or activities undertaken by the company. But now in these amendment rules, it is being substituted, and what it says that the CSR committee, now the CSR committee will formulate and recommend the board an annual action plan in pursuance of its CSR policy. Now what is it is the duty of CSR committee to look after the CSR policy. So now they will formulate and they will recommend to the board of directors that so and so we have made this annual action plan for implementing our CSR policy, and what are the lists that are required, the list of CSR projects or programs that are approved to be undertaken, the manner of execution, how they will be executed. There should be a proper planning of it, the modalities of utilization of funds and implementation, monitoring and reporting mechanism, who will look after that, whether the funds are being utilized in that way or not, details of need and impact assessment, if any, for the projects that are being undertaken. So the responsibilities of the CSR committee has been increased here. They will have to formulate and they will have to recommend to the board whatever the action plan they will make, and they will tell the board that like this we will be executing our CSR policy, provided that board may alter such plan at any time during the financial year as per the recommendation of its CSR committee based on the reasonable justification to that effect. Now, it can be modified, it can be altered, but it can be altered by the board if it is being recommended by the CSR committee, provided that justification should be very, very reasonable and genuine, then the board can alter it. In the new Amendment Acts Rules 2021, the rule number 6 is totally being omitted. Rule 7 has also been substituted. So before it was regarding the CSR expenditure that shall include like in contribution to corpus or project for projects or programs, the activities that are being approved by the board or recommendation but does not include any expenditure for conformity or in line with activities which fall under the areas or subjects specified in Schedule 7. So it is quite like you can say precise, but now in the new rules it's quite detailed. Let's see what is in it. So moving to the rule 7, in these amendment rules, the sub rule 1 says that the board has to take care, or the board has to ensure that the administrative overheads that was defined in rule 2, if you remember, the general management and administration expenses excluding anything for like designing, implementing, all those things should be excluded. It should be basic general management and administration expenses that shall not exceed 5% of the total CSR expenditure of the company for the financial year. So when you talk about CSR expenditure, board has to look into this, that the administrative overheads shall not exceed 5% of the total CSR expenditure that company is incurring. The administrative expenses should be less than 5% of it only. Then in case you have any surplus regarding CSR activities, any surplus is left arising out of CSR activities, that will not form any part of the business profit of a company. That will not be called as business profit if any surplus arises out of CSR activities. That the profit will be, or the surplus, I'm sorry, the surplus shall be plowed back in the same project, right? It will be put back into the same project. Or the second thing is, it shall be transferred to the unspent CSR account and spent in pursuance of CSR policy and annual action plan of the company. Or you can even transfer it to a fund that is specified in section 7 within a period of 6 months of the expiry of the financial year. So three things are there which you can do with the surplus. If any kind of surplus arises out of the CSR activities, you can either plow it back into the, like, invest it back into the same project, or you can transfer it to the unspent CSR account, and then further you can spend in pursuance of CSR policy and annual action plan, or you can transfer it to the fund that is specified in section 7. And all these transfers you can do within a period of 6 months of the expiry of the financial year. Now, subrule 3 states that if a company spends an amount in excess of the requirement provided under subsection 5 or 135, you're spending excess. So such excess, it will be used as a set-off up to immediate succeeding 3 financial years, right? It will be used as a set-off for the succeeding 3 financial years, immediate succeeding 3 financial years, subject to the conditions that, now there are certain conditions, like the excess amount for set off, it shall not include any kind of surplus, which I told you under subrule 2, it shall not include any kind of surplus, and the board of the company shall pass a resolution to that effect. So proper board resolution shall be passed to this effect. Subrule 4 states that if CSR amount it is spent for creation or acquisition of any kind of a capital asset, that shall be held by, which shall be held by, like, a company under section 8, a registered public trust or registered society having charitable objects, or beneficiaries of the said CSR project, like self-help groups or collectives or entities, or a public authority. So yes, it can be spent on the creation or acquisition of capital asset held by, so the companies that are being told under clause A, B and C. And provided if you have any kind of capital asset, such capital asset before the commencement of these amendment rules 2021, so you will have to comply with the requirement of these rules within a period of 180 days from such commencement, which can be extended to further period of not more than 90 days after approval from the board based on a reasonable justification. Rule 8 is also substituted. Earlier it was on CSR reporting, but it's quite less. Now it's more detailed. So Rule 8 under the new amendment rule states, again it's regarding CSR reporting only, but it's a bit more elaborated and detailed. Like, it states that the board's report of the company covered under these rules, it shall include an annual report on CSR containing particulars specified in Annexure 1 or Annexure 2, whatever is applicable, but it should, the board's report, it will have to include an annual report on CSR as well. In case of a foreign company, the balance sheet that is filed under clause B of subsection 1 of section 381 It shall also include an annual report on CSR containing particulars that are specified in Annexure 1 or Annexure 2 as applicable. So you see, it is regarding the CSR reporting. So it states that the board's report shall contain an annual report on CSR reporting, whether it's specified in Annexure 1 or 2, whichever is applicable. In case of a foreign company also, where the balance sheet will be filed under the clauses and the sections specified, an annual report on CSR reporting shall be filed as well, shall be contained as well. Subrule 3 states that every company having CSR obligation of 10 crores or more under 135 subsection 5 in the three immediately preceding financial years, they have to undertake a impact assessment. They have to get an impact assessment done through an independent agency of their CSR projects having outlays of 1 crore rupees or more, and which have been completed not less than 1 year before undertaking the impact study. So this is also kind of CSR reporting, that the companies who are having the obligations of like 10 crores or more for the three immediately preceding financial years, they have to undertake the impact assessment, that through an independent agency for whatever the projects they are taking out, they are carrying for 1 crore rupees or more, and they have completed not less than like 1 year has been passed after the completion for undertaking the impact study. The impact assessment reports shall be placed before the board, and they will also be annexed to the annual report on CSR. So it's very important that the impact reports will be shown to the board and will be annexed alongside the annual report. Then a company undertaking impact assessment may book the expenditure towards CSR for that financial year, which shall not exceed 5% of the total CSR expenditure for the financial year, or 50 lakhs, whichever is less. Now, as told, it should be through an independent agency. So whatever the company that is undertaking the impact assessment, that could also be booked as a CSR expenditure, provided that that expenditure, it shall be less than 5% of the CSR expenditure for that financial year, or 50 lakhs, whichever is less from the both amounts, that amount can be booked as CSR active expenditure. Rule 9 is also substituted, which states that earlier also it was display of CSR activities on its website. The same is display of CSR activities on its website. So it shall mandatorily disclose the composition of the CSR committee, CSR policy, and projects approved by the board on their website, if any, for public access. Now, if you are carrying it, the public should also know what CSR activities you are carrying out, so the board has to approve it, and the word mandatorily is written so like clearly. So now the company has to disclose the composition of who all constitute your CSR committee, what are your CSR policies, and what projects you are carrying out to satisfy the CSR requirements. Transfer of unspent CSR amount states that until a fund is specified under section 7 of subrule 5 and 6, the unspent CSR amount that shall be transferred to any fund that is included in schedule 7 of the act. Earlier, there was just one annexure. So now in the amendment rules, what they have done, that annexure is numbered as annexure 1. So annexure 1, and then it's after the words that's written board's report, new words have been inserted. That is for the financial year commenced prior to first day of April 2020. So when you'll write board's report, you'll also have to write for the financial year commenced prior to first day of April 2020. It's written basically. So the annexure, now these words and figures have been inserted in that annexure 1, and a new annexure 2 is also inserted. That is format for the annual report on CSR activities to be included in the board's report for financial years commencing on or after first day of April 2020. As you saw in CSR reporting, that annual report on CSR activities, that is to be contained alongside the board's report. So for that, now it's very important. So this is the format of the annual report that I told you at the time of CSR reporting. The format of Annexure 2 states that firstly you have to give an outline of your CSR policy, what is the composition of committee, then the website, whatever the website on which you're giving all the details regarding the CSR, details of impact assessment that I told you that for the companies that are stated under the rules, you have to attach their report approved by the board, that whatever the impact assessment is there regarding the projects, you have to give here. Details of the amount available for set off, whatever the amounts are for set off, the amounts are there, you have to give all details. Moving forward to average net profit for the company, then 2% of average net profit, surplus arising out of CSR projects, amount required to be set off, and D is total CSR obligation, that is 7A plus 7B plus C. Then under 8 states CSR amount spent or unspent for the financial year. Then you have to give the details of regarding this amount of CSR that you're spending on ongoing projects or other than ongoing projects. You have to fill all these details. It's quite a detailed form. Then amount spent in administrative overheads that are being defined in the definitions. Amount spent on impact assessment, if applicable. I told you that there's a limit according to which you can take it as a CSR expenditure that I explained you earlier. Then total amount spent. Excess amount for set off, if any, you have to give here. Details of unspent CSR for the preceding 3 financial years you have to give here. Moving forward to the details of the CSR that will be spent for ongoing projects of the preceding financial years, then in case of any capital asset, you have to provide all the details regarding that also. And in case the company has failed to spend 2% of the average net profit, you have to specify the reason also. Then the signs are required of chief executive officer or managing director or director, and of chairman CSR committee, and of person specified under clause D of the subsection 1 of section 380. This is wherever it is applicable, but other than that, these two people are required. Now, if you click yes in number 2, which was whether the entity is established by any company or group of companies, then you have to tell the SIN and everything. You will pre-fill and everything will be there. You have to add as many companies are there which have, if there are group of companies, and if no, then whether the entity has established track of records of 3 years and undertaking similar activities. Here also you have to go for yes or no. Then you have to tell the type of existing entity, the SIN, name of entity, date of incorporation of entity, address of the entity, email, enter OTP for email, PAN, and details of directors, board of trustees, chairman, CEO, secretary, authorized representatives of the entity. You have to give their names, designation, PAN, and email IDs. So whoever is signing your form, whether it's CA in whole-time practice, CS in whole-time practice, or CMA in whole-time practice, you have to sign and you have to select it, give your, whether you're an associate or fellow, membership number, certificate, practice number, you have to give such details. Then comes attention is drawn to provisions of section 448 and 449 which provide for punishment for false statement or certificate and punishment for false evidence respectively. Now here comes, now the form is being this e-form has been taken on file maintained by the registrar of companies through electronic mode. So this is how you have to file the CSR1 form that has come up alongside the amendments with effect from first day of April 2021. I really hope that you found the video informative. Do share it with your friends, with your colleagues, to help them and tell them what all has come up in these amendments. And please subscribe to my channel if you have not done it yet, and follow me on Instagram as well to stay connected with me.